Good afternoon. Welcome, all Facebook listeners. My name is Steve Grabenstein, and I'm joined this afternoon by my partner, John Veazey. We're both attorneys with the Van Winkle Law Firm, and we are presenting today the final installment. Yes, the final installment of 16 presentations that we've been doing over the last 8 weeks on a variety of trust and estate topics. John, where has the time go? It's just been a remarkable and a hopefully educational 8 weeks. Today's topic is, can we do that? Modifying and terminating irrevocable trusts. As you'll hear, the short answer to that question is yes, you can do that. And we'll get into why that is so. But before we do that, there's a couple housekeeping things that we like to touch on at the beginning of these sessions. The first is that John and I are practicing in Asheville, North Carolina, and across the state of North Carolina. And the topics we're going to talk about today reflect the law as it applies in the state of North Carolina. The law in your state may be different if you're viewing from Guam or some other interesting location. So always a good idea to make sure that you're looking at the law in your jurisdiction. And the second thing to bear in mind, and we've tried to point out in this series, is this is an educational endeavor on the part of attorneys at the Van Winkle Law Firm. We're not out here giving legal advice on specific situations and specific cases. If you have a situation where you're needing or wanting legal advice on a question, maybe it's related to the topics we'll be talking today, consult an attorney. Maybe consult John or me. We'd be happy to answer your questions. So, John, today's topic, this issue of modifying and terminating trusts, is a bit of a brave new world that in at least the life of my practice has changed pretty dramatically. And it's become much, much easier in the past 15 years to modify and terminate trusts. And we're going to discuss the different ways that you can go about modifying and terminating a trust, both with and without court action. But before getting into some of those particulars, it might be helpful for some of our listeners to hear why in the world would somebody want to modify a trust. And a couple of situations come to my mind. The first being, there might be ambiguities in a trust, that you've got a trust document that simply is unclear, creates confusion for the trustee or the beneficiaries, and it's just a good idea to clean that up. A second situation, one that I've certainly seen in my practice, is trusts can be old. I've dealt with 30, 40-year-old trusts, and the provisions that made sense 30 or 40 years ago may not make a heck of a lot of sense today or for today's beneficiaries. John, are there other situations that come to your mind in terms of why somebody might be wanting to modify or terminate a trust?
Well, sometimes people just don't like the terms of the trust. I think as we discuss it, we'll sort of reach the conclusion that if that's the reason, that might be the hardest time to get the trust modified or terminated. I also think that, sometimes it's not a change in just that the trust is old, but it's a change in the people who are either beneficiaries or trustees of the trust. And so the trust was working, but and would continue to work, but the trustee who handled it for 30 years is no longer living, and the trust terms don't address what's to happen at that point. So those are just a couple of additional reasons that I think people look to modify. Or
And we're just barely scratching the surface. There literally are a host of reasons that have driven people to see us about modifying trust or exploring termination of the trust. John, your practice focuses primarily on planning and drafting estate documents. I tend to get more involved in court proceedings involving trust documents. Um, I'll deal with what goes on in my universe in terms of modifying a trust towards the latter part of this presentation. But why don't you spend some time talking with our viewers today about what's out there and what can be used without going to court to try to modify and terminate a trust. And I'm looking forward to hearing about that Venter term, decanting, John.
Okay, so in my experience, there's many different types of irrevocable trust, but they sort of fall into a couple of different categories when we're talking about reasons why someone will want to terminate or modify. One type of irrevocable trust that I deal with a lot is really, it started as a revocable trust, which was created by the grantor for estate planning purposes and to control the distribution of their assets after their lifetime. And our law partners, Coral Allman and BJ Kilgore, did an excellent topic presentation on why you might use a revocable trust and how it's used. But if it is a revocable trust because the person who created it can revoke or amend it, then at that person's death, it becomes an irrevocable trust. And generally speaking, at that time, it provides new provisions about what's to happen with the individual's assets, whether they're to be distributed to certain individuals, whether they're to continue in trust for the benefit of other individuals. And in my experience, what often happens here, and why the reason that people often want to modify the trust that became irrevocable for this purpose, is either that they don't really like the terms, or they don't think that the person who created the trust really knew what they were doing. That's a topic that's covered by a presentation that Steve and our law partner Heather Whitaker Goldstein did earlier about will caveats and challenging the document itself. Or
what a great presentation that was, by the way, John.
You can find it on our Facebook page or on our firm's website if you're interested in it. Or it's because the terms are, as Steve mentioned earlier, ambiguous. So when it comes time to administer the trust and do what the grantor wanted to happen with their assets, either because there's conflicting documents or the language is just not clear, we can't exactly figure out what's supposed to happen. And so you can start in that circumstance. You'll sort of find all the beneficiaries and you'll see if you can reach some sort of an agreement about how to reconcile the terms of those trusts. And if all your beneficiaries are adults and they're all competent and they're all in agreement with what should be done, you might find that you can work through the document and you can distribute something that everybody feels comfortable with and that everybody can sign a receipt and a release, and they'll say, and you can move on. On the other hand, if some of your beneficiaries are minors and there's nobody that can represent them, or if, more importantly, your beneficiaries don't agree on how to resolve that ambiguity, that's when, in my practice, I would be calling Steve and saying, Steve, what can we do through the court system to try to resolve this ambiguity? And do we have to have a full-blown litigation type event, or is there some sort of, if we can mediate to an agreement, is there a less cumbersome and less expensive method that we could use to resolve these ambiguities?
Yeah, and I think it's worth mentioning, as I did at the outset, that the landscape that we work in really changed dramatically in 2006 in the state of North Carolina. Because in 2006, our state legislature adopted North Carolina's version of the Uniform Trust Code. The Uniform Trust Code has been adopted in a number of states. I haven't kept up with the total number, John. I don't know if you know that off the top of your head, but it's probably 20, 25 states now have adopted the Uniform Trust Code. There are slight variations from state to state in the provisions of the UTC as it's known. But prior to the enactment of the UTC, I think it's safe to say that the view, certainly of the courts and of most lawyers who worked with trust, was whatever the grantor, the person who drafted the trust, put in that document was etched in stone. That was it. You couldn't change it. If it was an irrevocable trust, that was it. You just had to follow whatever was in the document. That is no longer the prevailing view after the adoption of the UTC. The legal system, courts, lawyers, much more receptive now to modifying and, if appropriate, terminating irrevocable trusts. Personally, I think that's a good thing for many of the reasons that we've already talked about. Having this more relaxed approach allows for greater flexibility to deal with situations that arise today versus a situation that somebody was looking at in the 1970s when they were listening to their Elton John records. So, John, do you share my view that this is a good or a bad thing? What school of thought are you in?
No, I think it's a good thing. I think when I'm working with a client and we're drafting the terms of a trust, what we're really trying to do is be able to create a document that will operate in the way that the client would have operated if they were still with us. And then the problem is when we're drafting it, we can't identify everything that might happen in the future. So I'm a big fan of trying to get flexibility to either the trustee or some other power holder in the trust who the grantor or my client trust to address changing circumstances. And then I'm also a fan of the changes in the law that, even if those powers don't exist, allow the court to serve in a sense in that role of recognizing that the facts as they were anticipated or existed at the time the trusts were created may not be the same. And that we ought to try not to just look at the words in the document, but understand what the person who created it really wanted to happen and what their goals were related to those documents.
Yeah, and this more, I'm going to call it a more relaxed approach to modifying and terminating a trust is probably most evident in the topic you just touched on a few minutes ago, and that is modification or termination by consent. And I think it's important to touch on at least the statute dealing with modification and termination by consent is dealing with non-charitable trusts. Now, we got to go into a little bit here. Non-charitable trust is somebody making distributions or calling for distributions to individuals and not nonprofits. A charitable trust obviously set up to benefit charities. But John, there's this thing called a split interest trust. What is that?
Well, a split interest trust is where you have some beneficial interest to individuals and some beneficial interest to charitable organizations. So you have to typically either the charitable organization has a interest at the beginning and the remainder of the trust assets will go to individuals, or you can reverse it and certain individuals will receive a benefit from the trust for a period of time or their lifetime. And then the charitable organizations will receive the benefit after that individual's death or when the term ends.
And for the purposes of our conversation today, a split interest trust gets treated as a charitable trust when you're looking at these statutes governing modification or termination. So modification or termination by consent is pretty darn simple if the grantor, the person who created the trust, is is alive. If the grantor is alive and the grantor and all of the beneficiaries agree to a modification or to terminate the trust, they can do it on their own without any court action. We've done those with relatively simple, straightforward agreements. They're kind of simple to prepare, and that's all you need is an agreement signed by the grantor and the beneficiaries. And again, that kind of relaxed approach makes a lot of sense. If the person who created the trust and all of the beneficiaries of that trust think, well, we ought to make a change or terminate it, why shouldn't they be allowed to do so? Mm-hmm. So that's tool number one, and it's a pretty darn simple tool. If the grantor is not alive or doesn't give consent, you're in a little bit of a different situation, but again, a relatively simple situation if all of the beneficiaries consent to a proposed modification or termination of a trust. You do have to get court approval in that situation, but you're going to get court approval if you can show the court that terminating a trust is appropriate because the trust is simply not necessary. Continuation is not necessary to achieve a material purpose of the trust. If you're trying to modify a trust by consent where the grantor is either no longer living or not giving consent, you've got to show the court that a modification is consistent with the material purpose of the trust. And this doesn't come up all that often, but there are certainly situations where you don't have modification that is consistent with the material purpose of the trust, but a court can still approve it by statute if the modification or termination substantially outweighs the interest in accomplishing a material purpose of the trust. And it's worth noting that even if you don't have full agreement amongst beneficiaries, the statutes allow you to try to get court approval of a modification or termination by the courts. I mean, in my experience, John, we don't do that often because it's a real uphill climb if you don't have all the beneficiaries on board with the proposed modification or termination. In my experience, it's unlikely that you're going to find a judge who thinks it's a good idea to make a change. Is that consistent with what you see?
Yes, I think when you're not dealing with an ambiguity, I think they will step in if it's ambiguous terms and try to determine how those ambiguous terms should be reconciled. But if the terms are clear and you don't have consent of the parties, you're going to have a difficult time modifying or terminating the trust.
The second area that comes up in my practice with modifications involves what are known as unanticipated circumstances. That if you've got a situation where you have a provision in a trust and then something has happened where the grantor just didn't anticipate it, that's a great basis to go into the court because the statute speaks directly to it. You do need court approval. Unanticipated circumstances might be changes in tax laws. It might be the situation you mentioned earlier, John, where the tax laws or the provisions are very old and it just doesn't make sense today. I know this, you know this, but it might be helpful to hear from you because you deal a lot with tax matters about the changes that have taken place in tax laws over the last 10 to 20 years.
Well, I think the primary change that has caused a lot of desire to modify, terminate some trust is that not too many years ago, the exemption from estate tax or the amount that you could pass on to beneficiaries without paying estate tax was relatively low in the 600,000s. And it was a use it or lose it exemption. So if you had a married couple, the first spouse to die had to use their exemption in order, or else it was lost. And so that meant that lots of trusts were created for the benefit of a surviving spouse and family, often called family trust, that had about $600,000 or so of assets put into them. And then over the course of recent years, the exemption has skyrocketed, and we've gotten a term called portability, which means that if one spouse passes away and doesn't use their exemption, the other spouse can stack the exemption on top of theirs. And the result is that under the current rules, each spouse has an $11,580,000 exemption from estate tax. And if the first spouse doesn't use theirs, you can see you can get over $23 million of exemption. And so what has happened is we have a lot of trust with a relatively minor amount of assets that were created primarily for the purpose of using someone's estate tax exemption. But now the surviving spouse has such a high exemption, they don't need the trust to shelter. They wouldn't pay estate tax even if the trust assets were back in their individual name. And in my experience, clients don't really enjoy the hassle and the extra tax returns and things like that of a trust that they don't view as providing them any real benefit in the future. So we've seen a lot of people who have come in and said, what can we do about these trusts that we don't think we need anymore, and we don't think are serving the purpose that they were intended to serve when they were created?
And you've touched on yet another doorway that can be gone through to terminate a trust, and that's when you've got an uneconomic trust.
Correct.
And that's another easy procedure to follow. I believe the threshold is $50,000. Is that correct?
That is correct.
And if you've got a trust that's got $50,000 or less in it, the trustee can more or less decide this just doesn't make sense to keep incurring the time and expense of administering a trust with $45,000 in it. And I don't believe they require court action to terminate in that instance. Do they, John?
I think no court action is required.
It's a very simple, straightforward process, and a good one to be mindful of, particularly for people that are serving as trustees of these small trusts. That can be an administrative headache that they can get out of very quickly and easily. Another area we've sort of touched on and alluded to, we've been referencing ambiguities. Another word for ambiguities is mistakes. The person drafting a trust sometimes will make a mistake in the terms. The grantor will tell them X and somehow it gets written down as Y. So the law allows trust to be modified to correct mistakes, Scrivener's errors typically. John, in my view, the law has changed with that particular statute in ways that I think have been unhelpful in recent years, because the statute now requires that if you're going to correct a mistake, that the terms of the trust be ambiguous. I think we've both seen situations where the terms of a trust are very clear. They're not ambiguous at all, but it's still a mistake. It's not what the grantor intended. And in addition to that, the statute requires now clear and convincing evidence to correct a mistake. That's a pretty high standard. I think those changes did not move in a good direction. What's your take on that situation?
No, I mean, I agree with you on that. Everybody who's drafting documents is a human who will make some mistakes, and I wish the court would allow those mistakes to be remedied not in a way that we would worry that the intent of the client's not followed, but in a way that when the intent of the client is clear, there's an avenue to pursue it. There's sometimes the mistake, or I've seen times too, Steve, where the ambiguity is caused maybe not by bad drafting, but just the passage of time.
Right.
Seen documents where clients have written on the documents after some period of time, or where they have an estate plan and they've changed the entire plan by beneficiary designations or joint account ownership that was implemented many years after the plan was put together without coming back and trying to meld them together. I wonder, Steve, well, we got a little bit of time. I thought I might talk about some of the times when you don't have to go to court to get it modified or terminated. One thing I would say is anytime I get a trust, including ones that I've drafted where the client wants to modify or terminate, the first thing that I do is sit down and read the actual trust terms. Many of the statutes, provide a baseline, but can be overridden or changed by the trust terms. For example, I have provisions in most of my trusts that allow the termination of a non-economical trust that would have more than $50,000 worth of assets in it.
Good point.
I allow the consolidation of trust if there are more than one trust created for a certain beneficiary and they have similar terms, and I would allow the consolidation in my documents of more trusts than are permitted under the statutes. Sometimes the trustee or another power holder in the trust, I call them a trust protector, will be given the ability to modify the terms of the trust. I often do this if I'm preparing, for example, a special needs trust where the statutes can change all the time. I will provide that a trust protector has the authority to modify the terms of the trust to match up with the new statutes so that the trust will continue to qualify as a special needs trust. If you have discretion for distributions, you can sometimes deal with issues that would otherwise require going to court simply by the way that the trustee exercises their discretion. And that sort of ties into the topic you mentioned at the beginning, Steve, which is decanting.
Decanting, yes.
And it's at the risk of oversimplification, decanting is if you have a trust that has multiple beneficiaries in it, sometimes called a pot trust or a family trust, and the trustee has discretion as to distribute the income and the principal between those beneficiaries without any certain requirements about which beneficiary would get which amount or distributing things in an equal amount, then the trustee can use a new procedure called decanting that's authorized by the statutes, where they can actually create a new trust, and exercising their powers of discretion, they can move some or all of the money from the original trust into that new trust. This is particularly useful if, say, the terms of the language are very old and they just don't have they don't reference the current statutes, they don't have flexibility for the trustee to really act in the way that a trustee needs to act. You can update the terms of the trust. You can use them for sometimes you can decant to a new trust that gives somebody what's called a general power of appointment, which is a tax planning technique that we will use to try to get a better tax benefit from the trust. If you've got a bunch of beneficiaries in a large trust and they just can't seem to get along, or they have different investment horizons, sometimes you can decant one trust into multiple other trusts and separate out the different beneficiaries. What you cannot do with decanting is you really can't add beneficiaries to the trust, and you can't delay the terms of the distributions from the trust. So if you have a beneficiary who's about to turn 30 and get all the money, but you really don't want them to get the money, you're probably not going to be able to decant to a trust that keeps it in there for their lifetime. The other thing I would say about decanting is it doesn't require you to go to court like some of the modification techniques that Steve was describing, but it does require you to notify people who have an interest in the trust, such as the grantor and the beneficiaries, that you're going to decant. And it provides them with a time window where they can go to court and challenge your action. Right. So decanting can be very useful when you've got a common goal that you're trying to achieve for the beneficiaries and you have everybody on board. But if you just don't like a beneficiary and they want all the money and you're trying to get rid of them, you're probably not going to succeed with a decanting. You're just going to end up back in court.
That's going to generate work for me, John. That's what that situation is going to do. You know, we've been we're running up on our time, and I realize we haven't even touched on a host of topics here: charitable trusts, cypre, the process for modifying a charitable trust, the involvement of the Attorney General in modifications or terminations of charitable or split interest trusts. But I think the primary takeaway to me from this conversation is sort of what's implicit in the title of this presentation, and that is most folks are simply not aware of the array of tools that are available to them to modify or terminate an irrevocable trust. Um, it's a great system, pretty wide system out there. And I think our advice would be, if you're wondering about the terms of a trust, can it be modified or terminated? Pick up the phone, call John, call me, call any other attorney at the Van Winkle Law Firm, and we'd be happy to talk with you about the situation. John, am I correct in thinking that we've exhausted our 30 minutes?
You are correct. And I'll throw out a reminder that all of our prior presentations are available through Facebook and will soon be available on our website if you're interested in any of the topics we mentioned, or just want to see a list of the entire 16 topics that have been discussed during this series.
It's been a wonderful run and series of presentations over these 8 weeks. Thank you all for watching and listening, and we look forward to following up with you. In the meantime, be safe, stay healthy. Thanks.